you want to actually have what we call a memorandum of land contract.
Okay,
That's
the next question is, what is a memorandum of land contract? So let's just go right into that.
Right, well, we are. Okay, so you want a memorandum of land contract, which is just it's a document. It's just usually one page. It memorializes the agreement that the buyer and the seller engaged in when they did their financing. And it's that document that actually references the land contract. It doesn't talk too much about the terms, okay? It just says, and you need this memorandum, if you want to protect yourself as a buyer, you need this memorandum filed, because without it, nobody knows that you purchased this property on land contract. And so the seller, and this happens all the time, this is what I'm telling you about when people do it on their own. The seller could go and sell that property to somebody else, and nobody would be the wiser. I mean, if you're living there,
right,
that's one thing, but if you're not living there, if you're an investor and you have tenants, I mean, that's why you need to have a memorandum of land contract filed. So it just tells the whole world, hey, there's an agreement on this property between the buyer and the seller, and we're letting everybody know about it. We're not telling you the terms. We're not doing anything else, just memorializing that there's a relationship there. You're not doing anything else. Well, why do you need it? You also need it for the bank. Because when a bank wants, if you go for bank financing, that bank is going to say, well, how do we know you have a land contract?
Right.
You know, that's real. And they assume it's real if you're going to record something that would be against anybody's interest. So the memorandum is enough. The bank will still want a copy of the land contract, but they still want to see a document that's been recorded with the county. And it's that memorandum that gets recorded. Okay. And the bank's countdown date, I'm sorry, I'm a finance attorney as well. And the bank's countdown date, they go and they use the date of filing of that memorandum of land contract for the date at which they start counting how many months or years that you've been into that property. So,
I gotcha.
Right. I mean, so there's a lot of mortgage people who watch this.
Not your purchase closing date or when you sign the land contract, but when the county filed, the date that the county filed that memorandum.
That's right.
Okay.
That's correct.
And then going back to what David had said earlier, you know, if you're just jumping into the conversation, when you purchase on land contract, you don't, in Michigan at least, I'm not sure how it goes nationwide, but in Michigan, you don't receive the deed until you've completely executed the contract, which means you paid it off or you've refinanced or whatever. So because you don't have the deed to the property, that memorandum of land contract is so important because you literally don't have any evidence other than the land contract that you have and your seller has, but that's just a piece of paper that's signed between a couple of people. So then where does the land contract exist then for those who are asking, okay, well, I file a memorandum of land contract with the county. And if you purchase through a title company, my title company drafts it and files it for me. But where then does the land contract live in the meantime?
Well, it lives, usually the land contract will have a provision, it's called a counterpart provision, okay? And in there, if it's done right, in there, the counterpart provision basically says that a copy of the a signed copy of the land contract is just as good as the signed original land contract, okay? So you have the original and then you have a signed copy, both have legal effect. You give one to the seller and one copy to the buyer. Now, I have a paralegal in my office. All we do on a regular basis is we're chasing after people for signed documents because people have walked away and never received their signed documents, usually from the seller, okay?
Right.
But it also goes the other way. I mean, I have a land contract forfeiture I'm doing right now, and my seller doesn't have the land contract. He gave it to the buyer. This is what happens when you don't have attorneys. Gave it to the buyer, waiting for it to come back, never got the signed copy back. And, well, he doesn't, he can't enforce it because we don't have a copy of the land contract.
Wow.
But that's okay, because then we just consider them a tenant. And we start the transaction, we start the default as a lease. And guess what? That flushes out the land contract really quickly. Okay.
I'm sure it does.
It sure does. But, again, people
it was here the whole time.
Yeah. But, because a land contract interest, of course, is much better than just being a tenant, right? But people leave the table. There are times that people don't close transactions with title companies or with attorneys. And that's when you have the problems. You need copies of documents. A biggie right now is, of course, the principal tax exemption, the primary residential tax exemption, the homestead exemption. Many assessors will use the land contract and give the land contract purchaser the homestead exemption, so the taxes are less.
Mm-hmm.
If you're the seller, you want that too, right? Because that frees up more money for your buyer to be able to pay you and not trip up because it's a non-owner occupied property.
Mm-hmm.
Okay, that goes along the line again when we deal with who has title. We talked about legal interest and equitable interest. Well, most assessors will still look at the equitable interest and say, yeah, we know you're not in title. We know you don't have a deed, but we will honor the land contract to give you the homestead. One more thing, the assessor is going to ask, by the way, did you file your memorandum of land contract so you can prove to us that this is a real land contract? Do you see how this all works?
Mm-hmm.
Property law is really fascinating. I'm not here to, probably most people are bored by it, but I've told you that it goes back almost 2,000 years, okay? With England, when the French king came over to England, William the Conqueror, that's when real estate law started to develop, and that's what we kind of work with all these years. It's just now been codified into statutes. So this stuff has been figured out over the millennium and how things actually operate and kind of work together. It's kind of cool.
It is cool. And
that's a history lesson. We'll talk another time on that.
Right.
But
so the land contract.
Yeah.
A copy should be made, and one should live with you, and one should live with the other party.
Right, and both have legal effect.
Mm-hmm.
Right, both have legal effect if you make it so within the contract. Then you can also take copies of the deeds. Now, the seller doesn't give the deed to the buyer, of course, but you can have the seller can actually execute the deed right there. Usually they should, and that should be going into escrow with the title company, and the buyer will get a copy of that. So later on, God forbid the seller dies or there's a divorce or whatever, and you have this information so that you can trace it back and show whoever is important in your financial life or in your banking life to say, see, I own this property or I have an interest in this property.
Okay.